Welcome back to the Constitutional Clarion. Regular viewers will know that I've now done a number of videos concerning disqualification from Parliament for conviction of a criminal offence and also the power of a House of Parliament to expel a Member of Parliament. This issue has arisen in New South Wales after a Member of Parliament, Gareth Ward, was found guilty of serious sexual offences for which he has not yet been sentenced and which he intends to appeal. Unlike most jurisdictions, in New South Wales, the Constitution was amended in 2000 so that disqualification does not occur upon conviction, but rather upon the exhaustion of any appeals. As Mr Ward, who at the time of recording was being held in custody, has indicated that he will appeal, he could remain a member for quite some time, drawing a full salary while in prison and unable to fully represent his constituents in Parliament. The New South Wales Legislative Assembly proposed to expel Mr Ward this week on the basis that his continued membership of the House brings the House into disrepute and undermines the capacity to fulfil its functions with public trust. On Monday night, Mr Ward obtained an ex parte interim injunction from the duty judge in the Supreme Court, which orders that the Speaker of the House, the Leader of the Government in the House, and the Clerk of the House be restrained from taking any steps to expel or otherwise resolve to expel Mr Ward. This injunction applies until Friday. The Legislative Assembly ceases sitting on Friday for a month, while estimates committees are being held instead. The government has sought an urgent hearing from the New South Wales Court of Appeal on Thursday morning to deal with both the injunction and Mr Ward's challenge to the validity of his proposed expulsion. Given that these legal proceedings are on foot, what I'm going to do in this video is just explain the issues that are being raised by both sides without preempting any conclusion of the court. I'll also keep the comments off for this video, given the sensitivity of the subject matter and the fact that it is subject to ongoing legal proceedings. The main reason for addressing it is that while it's on the one hand a very local New South Wales matter, on the other hand it does raise profoundly important issues about the relationship between the Houses of Parliament and the courts, which will be of interest in Westminster-style parliaments around the world. It therefore has international interest well beyond the local conflict. The two issues I'm going to address, therefore, are first, the substantive challenge to the power to expel Mr Ward and the court's role in relation to that, and second, whether a court can, or more relevantly should, issue an injunction that restrains a House from introducing and passing a motion. On the first issue, a court may determine whether the power of a House to expel a member exists and the nature and extent of that power. Whether it's appropriate in the circumstances to exercise that power remains a matter for the House. In other words, the courts decide about power and the Houses decide about the merits of the exercise of that power. Previously, the courts have held that a House of the New South Wales Parliament has an inherent power to expel a member based upon reasonable necessity. That power cannot be exercised for the purpose of punishing the member. It's not a punitive power. It's only a self-protective power. It must be exercised for the purpose of protecting the House's ability to fulfil its functions with the trust of the public. If a member of the House has engaged in conduct unworthy of a member, which brings the House into disrepute and undermines public confidence in the ability of the House to properly perform its functions, then it may expel a member. The most recent case to have addressed this issue in detail is Armstrong and Budd from 1969. That precedent, however, is now quite old, so it does remain possible that a court might take a different view today. While some concerns were raised about expulsion in the case of Egan and Willis in 1998, that case concerned suspension rather than expulsion, so those issues were not resolved. we do not yet have access to the submissions and arguments of the parties, so I'm going to do my best here to describe what I believe to be the main arguments that will be raised by each side as best I understand it. But of course, I might be wrong, so please take that into account. It appears that Mr Ward is likely to make four main arguments. First, there is the argument that since 2000, Section 13, capital A, subsection 2 of the Constitution Act 1902 of New South Wales provides for disqualification upon conviction of a serious offence to be deferred pending the resolution of any appeals. The argument for Mr Ward appears to be that the House has no power to expel a member while this appeal process is underway, as it would conflict with the Constitution and the role of the courts. The House is likely to respond that when the Constitution was amended in 2000, it was anticipated that the conviction of a member for some offences might be of such public concern that the capacity of the House to continue to fulfil its functions would be threatened. So the Parliament expressly included in Section 13, capital A, subsection 3, a provision which says, nothing in this section affects any power that a House has to expel a member of the House. The Minister in the second reading speech said, in some cases, the behaviour of the member may be such that it is unacceptable that the member continues to sit as a member while the appeal process is underway. In such cases, the House will retain its discretion to expel a member for unworthy conduct by way of a vote of the House. Mr Ward's second argument appears to be that the expulsion resolution is for the purpose of punishment rather than the self-protection of the House. The Houses of the New South Wales Parliament do not have the power to punish. In response, the House would most likely argue that it is the courts that are responsible for punishing Mr Ward in relation to offences for which he is found guilty, but it is the House that is responsible for protecting its reputation and capacity to function by removing him as a member because his ongoing membership is bringing the House into disrepute and undermining public confidence in it, affecting its functioning. Mr Ward's third argument appears to be that he has been denied natural justice by not being able to be present in the House to respond to the motion for expulsion. The House is most likely to reply that Mr Ward has been invited to make submissions in writing responding to the expulsion motion, which will be presented to Parliament and read into the Hansard record so that all members and the public can be aware of his arguments. Mr Ward's fourth argument appears to be that his expulsion would breach the principle of representative democracy because his constituents re-elected him, even when they knew of the charges against him. His expulsion would deny their choice of a member to represent them. The House would be likely to respond that when he was re-elected, the voters in Mr Ward's electorate were unaware of the evidence presented to the court in his trial, or that he would be found guilty of serious charges. The expulsion of Mr Ward would give his constituents the democratic right to vote again for their representative in full knowledge of the facts. Neither conviction nor expulsion would prevent Mr Ward from standing for Parliament again to fill the vacancy caused by his expulsion. Indeed, of those previously expelled by a House of the New South Wales Parliament, at least three of them, Ezekiel Baker, Paddy Crick and Richard Price, were re-elected by their constituents. If, however, Mr Ward were sentenced to more than 12 months imprisonment, he would lose his entitlement to enrol and vote in state elections while serving his sentence, with the consequence that he would also lose his right to nominate for election to Parliament while serving that sentence. Finally, the House would be likely to contend that the constituents of the seat of Kiama are likely to be poorly served by a member who's confined to prison. If Mr Ward is sentenced to a term of imprisonment, there would be an adverse democratic impact upon his constituents. Accordingly, the House could contend that democracy would be enhanced by giving them the opportunity to elect a member who can attend the House and serve their needs on a full-time basis. As I said, this is just a summary of the types of arguments that are likely to be made, but of course, different issues that I haven't anticipated may be raised and be decisive. Now, what about the court issuing an interim injunction that restrains the taking of any steps to resolve to expel Mr Ward? This is most surprising and unusual. Why? Because the courts and the Houses of Parliament have long accepted that a principle of comity applies, according to which each respects the other and restrains its own conduct so as not to interfere in the internal affairs of the other. With respect to the Houses, Article 9 of the Bill of Rights 1688, which does apply in New South Wales, provides that the freedom of speech and debate or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. Now, this is part of the reason why courts do not interfere with what are described as the intra-mural, within the walls, proceedings of the Houses of Parliament. But this principle does go further than questioning or impeaching. Internal parliamentary procedural matters are usually treated as non-justiciable by the courts, meaning that they are not the subject of judicial review or intervention. Examples include sections 53 and section 54 of the Commonwealth Constitution, which concern how the two houses of the Commonwealth Parliament deal with money bills. The High Court has long held that these are matters for the Houses to decide and that it will not interfere. The Privy Council said in the case of Prebble and Television New Zealand in 1995, in addition to Article 9 itself, there's a long line of authority which supports a wider principle of which Article 9 is merely one manifestation, that is, that the courts and Parliament are both astute to recognise their respective constitutional roles. So far as the courts are concerned, they will not allow any challenge to be made to what is said or done within the walls of Parliament in the performance of its legislative functions and protection of its established privileges. How does this principle connect with the power of a court to issue injunctions? In New South Wales, this was addressed by Justice Kirby when he was President of the Court of Appeal in a case called Eastgate and Rizzoli from 1990. The quote's a little bit long, but it does give a pretty stark picture of the reasoning that's at play, so it's worth quoting it in full. So here it is. Courts will not issue injunctions when they will not be obeyed. In the present case, the Speaker, out of comity, delayed the presentation of the bill to the Governor to permit the court to consider the motion of the claimant. This was done voluntarily by the Speaker. It was not done pursuant to an order of the court. If the court were to issue an injunction, it might be expected that it would be obeyed. If, however, Parliament declined to accept a perceived intrusion of another branch of government in its affairs, a risk of disobedience might arise. The court would then be faced with grave difficulty in enforcing its orders. Although under the Constitution Act 1902, there is not the same entrenched separation of powers as exists under the Australian Constitution, the mutual respect of each branch of government for the other requires caution on the part of the courts before they make orders affecting the internal procedures of the Parliament. End of quote. There have been a small number of occasions where the courts have issued injunctions in relation to a parliamentary matter or contemplated it to allow for a court to determine a legal issue. But this has been after the Houses have completed their deliberations on the matter rather than attempting to prevent them from deliberating at all. So, for example, there have been cases where a bill has passed both houses, but a court has intervened to prevent it from being presented to the Governor or Governor-General for royal assent, while the validity of the proposed law and whether assent can be validly given is determined. This is generally where there is a constitutional or legal requirement that the bill not be presented for assent unless it is passed according to a particular manner and form. Even then, such action has sometimes been criticised on the ground that the challenge should instead be directed at validity once a bill has received assent and become law. In July 2003, when it was proposed to expel Malcolm Jones from the Legislative Council after adverse findings were made by the Independent Commission Against Corruption, Jones went to the Supreme Court seeking an injunction. However, after Justice Windeyer indicated that this would not be appropriate, Jones withdrew his application and resigned from Parliament before the expulsion motion could be debated. So, what should have happened in this case? Ideally, both sides would have appeared before the court, and counsel for the Legislative Assembly could then have voluntarily undertaken, out of comity, to delay an expulsion motion to allow the court to hold an urgent hearing to address its validity. An injunction would have been unnecessary and inappropriate. The problem in this case was that Mr Ward's lawyers sought an urgent ex parte injunction late on the 4th of August. Now, ex parte means that the other side, the Legislative Assembly, was not represented and couldn't raise issues about privilege or comity or even make suitable undertakings. Now, this was surprising given that Mr Ward had been notified on the 30th of July that an expulsion motion was to be considered by the Legislative Assembly when it resumed sitting on the 5th of August. So there was ample time for an application to be made to the court at which both sides could have been represented and proper arguments made before the court and perhaps an undertaking of that kind as well. Thank you for watching the Constitutional Clarion. I hope this explains to you how we got to this rather unusual point. And like you, I will be very interested to see how the Court of Appeal deals with these substantial and quite interesting issues about expulsion at its hearing on Thursday morning. Goodbye.